Amosun, I represent Ogun Central. Mr. President, distinguished colleagues, let me start by thanking you for the opportunity to lead the debate on the general principles of the Child Rights Act 2003 Amendment Bill 2020. This bill was first read in this hallowed chamber on 27th November 2019. Mr. President, let me quickly say that this is a straightforward bill because it is just a minor amendment that we are going to effect in the extant bill. The objective of this bill, Mr. President, distinguished colleagues, is primarily motivated by the need to ensure the protection of the Nigerian child by excluding certain categories of persons from being employed as caregivers, teachers, or in any other circumstances that may expose or make such a child vulnerable or susceptible to sexual assault or sexual exploitation. In this regard, Mr. President, distinguished colleagues, the bill, which is an amendment to the Child Rights Act 2003, seeks to declare and prohibit persons convicted of attempted rape, among others, unsuitable to work with children. The background and current position of the law. Mr. President, distinguished colleagues, while the extant Child Rights Act in this bill referred to as the Principal Act should be hailed as the most comprehensive legislation on the rights and welfare of the Nigerian child, recent developments in our society underscores the need to take a second look at the Principal Act with a view to providing stringent provisions that will guarantee the safety of the Nigerian children from defilement or other forms of sexual exploitation in view of the rising cases of sexual violence suffered by Nigerian children in the hands of caregivers and others, whom for lack of appropriate legal restriction have found themselves in positions that give them undue advantage and access to the children. In other words, apart from the existing punitive measures in relation to sexual offenses against children, the thrust of this bill is preventive in nature, and it is in line with the time-tested wisdom that says prevention is better than cure. Mr. President, distinguished colleagues, sexual assault is fast becoming a cankerworm in Nigeria, as a day will hardly pass without reading or viewing the media cases of sexual assault suffered by Nigerian children in the hands of people who ordinarily should not be allowed to have custody or access to them for whatever reason. Accordingly, if this bill is passed, the Senate will have given a nod to the declaration that the following categories of persons are unsuitable to work with children. A. Persons convicted of murder, attempted murder, rape, indecent assault, or assault with intent to do grievous bodily harm with regard to a child. B. Persons declared mentally unstable and thus unable to enter defense in court against violent offenses such as murder, attempted rape, indecent assault with intent to do grievous bodily harm with regard to a child, and any person who has been convicted of murder, attempted rape, indecent assault with intent to do bodily harm with regards to a child in the last 5 years preceding the commencement of this bill. Mr. President, distinguished colleagues, this bill is therefore in tandem with global best practices regarding the safety of children and exclusion of sexual offenders from working with children. Mr. President, distinguished colleagues, in concluding, let me say that in compliance with Order 77.3 of the Senate Standing Order, as amended, I wish to state that this bill, when passed, will not attract extra financial burden on the Treasury of the federal government, and I therefore plead with my colleagues for the overwhelming support for its speedy passage, considering its importance in strengthening the protection of the Nigerian child. Thank you, Mr. President, and my distinguished colleagues for your time.
Thank you, Mr. President of the Omo Agege Delta Central Senatorial District.
Yes.
Mr. President, I want to join my colleague, Senator Yudu Olujimi, in commending Senator Amosun for bringing this amendment to the Child Rights Act. Mr. President, I commend him for putting forward this amendment to address this very, very specific issue. But I think, Mr. President, that we have bigger issues than is being canvassed in this amendment. Unlike, I'm not so sure how many of the states, frankly, that have domesticated this very child's right act. Many a time we've been accused of being very selective when we brought bills to address not just children, but people who are deemed to be of the weaker sex in terms of seeking protection for them. The argument has always been that, oh, we have laws, extant laws, to address issues like this. But, Mr. President, this is an act of the National Assembly, and that has implications. What it means is that we are only restricted in terms of application to the FCT. So the question becomes, how many of the states that have domesticated this very extant law? And what have we done, to encourage the states to domesticate this very Child Rights Act? Mr. President, I agree that if we're able to push for enforcement, most especially to the extent of the implementation of this sexual offenders register, most of the issues here canvassed by way of this amendment will be addressed. But we are told that the register is there, but nothing has been done. It is not just enough to say these people should not be allowed to make contact with children, but who are those who are giving employment in this very sector to these very people? And what sanctions have we provided in the extant law and also in the amendment to make sure that the people who engage the services of these people who are supposed not to be engaged because they're already in the sexual offenders register, what sanctions have we provided? I will support this very proposed amendment, but I think it should go further than just this right there. It should also go further to provide sanctions to punish those who, notwithstanding, proceed to give employment to these people who are on this register. So once again, I want to thank Senator Amosun for deeming it fit to bring this, but please make it a little bit more stringent, by providing sanctions for those who will go ahead and provide employment. Thank you very, very much, Mr. President, for this opportunity.
Senator Ibrahim Yahya Olura.
Distinguished colleague, Ibrahim Yahya Olura is my name. I represent Kwara Central. Mr. President, I decided to contribute because in the last 10 years or so, I've worked with child rights organizations, the Save the Children International and Plan International. I'm very familiar with this terrain. I want to commend and thank the sponsor of this bill. And to say that, just like the last speaker, there's 3 points I have. One is about the extent of domestication of the extant act in this country before we expand this one. I'm very much aware that many states are yet to domesticate the extant act, in which case part of what we should look at is, are there any way, probably we may have to go through the Constitution to be able to strengthen the implementation. Because just like distinguished Senator Olujimi said, children are very important for the development of any country. And if they are not well cared for, we have challenges with development and we have challenges with a lot of things in the country. My second point, Mr. President, is just that when the bill is being considered and deepened, one, we may have to expand those that may not be allowed to also be employed or to handle children. in child rights organizations, one of the questions you are being asked is that, have we ever engaged children in working? Many people, if you ask them in this country, they have so-called house help who are children. And this is not allowed because those children are deprived from their education, they are deprived from the God-given ability. And you have a lot of people that are in high places who, while their own children are going to school, they engage children in menial jobs or to be house girls. And we do ask, in child rights organization, you are not allowed to be employed or to work if you have ever engaged in something like that. This is one of the things I want to suggest to be included, to expand those that would have, if you are ever. The second thing is about how do we enforce this? It will require investigations because mere declaration does not matter. One is the register, but the other one is that means employer of labor will have to go further to investigate and know the personalities of people they want to engage. In which case, in considering this bill, appropriate agencies of government will have to be identified to enforce the law. So I therefore support this bill, and I hope when it is referred to appropriate committee, relevant technical stakeholders will be invited to enrich the content. Thank you, Mr. President.
Thank you very much. In favor that this bill be now read a second time, say aye. Those against say nay. The ayes have it. Clerk of the Senate.
Second reading.
A bill for an act to amend the Child Rights Act 2003 to provide for a person convicted of attempted rape to be unsuitable to work with children and for other matters connected thereto. 2020 second reading taken, and the bill is referred to the Senate Committee on Women Affairs to report back within 4 weeks.